is Jessica Peterson. I am the managing attorney here at JWB Family Law in San Diego, and welcome to Tuesday's Tips. Today I want to talk to you about move-away cases and what the court considers when deciding whether a parent is able to move out of the county or out of the state with a minor child or minor children. And there is a little bit of a different process depending on what your current custody orders are or whether there even are current custody orders. If one parent is already established as the primary parent, meaning they have more than 50% custody, they have what we call a presumptive right to move. This means that if you are the parent who is the primary parent and you want to move out of state, in order for the other parent to stop that move, they have to show the court detriment to the child, and that detriment has to be more than the effect on the parent-child relationship. Obviously, anytime a child is moving out of the county or out of the state away from one of the parents, that's going to have an impact on the parent-child relationship. But if we have a parent who is the primary parent, they are presumptively allowed to move, and so the burden shifts to the non-moving parent to stop the move. If we are dealing with a situation where the parents have equal custody or there are no custody orders, the court is, instead of anybody having the presumptive right to move, the court is going to look at a bunch of factors to determine what is in the child or the children's best interest. And that is really the guiding principle that the courts use, is what is in these children's best interest in terms of where they will have the most stability, which parent is more likely to facilitate the co-parenting relationship. The court will look at the distance of the move, how entwined the children are in extracurricular school activities in their current community, what the family support looks like in both places. And ultimately, the court is going to make a decision based on what they think is in the child's best interest. Another important piece that I tell a lot of my clients about a move away is that the court has to make a decision with keeping in mind that the parent who's asking for the move away is going to move. The court doesn't make orders based on, well, Dad, if you stay here, you can have this custody, or Mom, if you stay here, this is what we're going to do. The court has to make orders based on the fact that the parent who's asking for the move is going to move whether or not the child moves with them. So that's an important piece to consider when you're the moving parent. And so ultimately, in both types of cases, when we're talking about where there's a presumptive right to move and where we're looking at the factors to determine what is in the child's best interest, the court is ultimately going to make a decision based on what the judge believes is in the child's best interest. That's the most important thing. That's what the court is going to give the most weight to. If you are looking to move out of the county or the state, or your ex-partner has noticed you that they are going to move out of the county or the state, call our offices, set up a consultation. Move away cases tend to be a little bit more complex. There's a little bit more work that goes into them. And if you have questions, we are ready to help, ready to get you before a judge so that you can have that decision in the timeliest manner possible. Please do not hesitate to reach out to us. Thank you.